And we are here for now the final session on institutional issues about judicial involvement with politics. I am particularly looking forward to this. It is the most interdisciplinary of our sessions, and we have a number of people on this panel we are happy to welcome back. Again, starting from my immediate right is Mike Salamini from the University of Cincinnati College of Law. Mike and I go back a very long way, and last night at dinner I told him that I'm on our law school class reunion committee, and one of the things I need to do before he leaves town is to hit him up for some money for the class gift. But Mike has done a lot of very good work on federal courts and is the co-author of a new book on election law. Beside Mike is Margot Anderson, an urban and social historian from the University of Wisconsin at Milwaukee. Among her many works is a terrific book on the U.S. Census that was written a few years ago while she was a visiting professor of history here on campus. Our third speaker is Micah Altman from Harvard, who is a statistical person, for the senior research scientist. It says
90% of the time.
Institute for Quantitative Social Science. Right. Okay, and Michael McDonald, who is a political scientist at George Mason University. Seems to me that there's something odd about this background. We have two George Mason faculty, and we've got as well two Atlantans here. Our last person is a pleasure to welcome back Neil Kinkoff. Neil was my student many years ago. Neil was the kind of student you kind of love to have, but also dread, because you know that he's going to keep you on your toes. Neil also is a former colleague of mine, and he is, at least in my time, I would say, one of the all-time great editors-in-chief of our law review. So I'm looking forward to this session. Let me turn things over to Mike, and we'll go from there.
So this, first of all, thanks for the generous introduction and the opportunity to participate in this wonderful symposium. So this panel, the topic, the title of the panel is just right for me, because I want to back away a little bit from the Baker opinion itself per se, not be so court-centric, and talk about other institutions that relate to Baker versus Carr and subsequent reapportionment and related litigation like under the Voting Rights Act. So the topic of my paper is Congress, the Solicitor General, and the path of reapportionment litigation. So I want to talk about those two institutions, which certainly doesn't exhaust the universe of private and public institutions that can be that relate to reapportionment litigation. And so I think the paper has both a kind of descriptive and normative component to it. Part of it is just to describe how these other institutions have impacted reapportionment litigation, and indeed the reverse is true, how reapportionment litigation has impacted those other institutions, and also, at least implicitly, ask, is it a good or bad thing, and what exactly do you mean by that in this context? So before getting to talking about the Solicitor General and Congress, in that order. Just very briefly, wanted to indicate and talk a little bit about Baker versus Carr itself, and building on what Professor Ishikaroff and others have said about the case. I think it's fair to say that the conventional wisdom today, at least, is that Baker versus Carr, after being briefly controversial, quickly came to be accepted, and this is often contrasted to the more controversial Warren Court cases. So one, just as one of many examples of that kind of current view of Baker, is that someone in 2006 said the following. This is in 2006. It is difficult to imagine in this day and age any serious objection to the rights identified in Baker versus Carr and subsequent reapportionment cases. That was Professor Samuel Ishikaroff's testifying to Congress in 2006 during the hearings to confirm Samuel Alito to the U.S. Supreme Court. But in fact, as Professor Ishikaroff and others have written, in the early 1960s, I think it's fair to say, late 50s, early 60s, that it wasn't inevitable, despite its later, yes, quick acceptance, relatively quick acceptance. I think that the Baker litigation and the reapportionment issue in general was, at least the way I see it, was not completely inevitable, was indeed controversial for its time. I mean, it's been mentioned some of the reasons that due in part to the Coal Grove versus Green case and other cases in the 40s and 50s, the lower federal courts and state courts were relatively passive on this issue. There was not a great deal of movement in the states, much less the federal level, in Congress or elsewhere, to change the many malapportioned districts, despite people lamenting about them. There was, very little being done about it, I guess I'm saying. So hence, despite its later acceptance, Baker was, I think it's fair to say, from when you look at the state of the, politics at the time, was indeed a controversial matter. And I don't, at least the way I see it, I don't think it was inevitable that the Baker decision came out as it did. And I think, without going into all the details, I think at least the immediate aftermath of Baker, by which I mean the next 2 years up to the Reynolds versus Sims decision, it was pretty controversial, even though, yes, fairly rapidly and perhaps surprisingly, perhaps not, after that it came to be accepted. So the reason I point that out is just as a preface to talk about the Solicitor General and Congress's kind of reaction to it. I think that's an important, perhaps unappreciated part of the story, which kind of, at least as I see it, affects reapportionment litigation up to the present day as well. So let's talk a little bit about the Solicitor General. Professor Ishikaroff talked about this as well. He mentioned that the U.S. got involved in the Baker litigation, and that's true, but not as a party. The U.S. wasn't a party, but rather the United States, through the Solicitor General, filed what has come to be seen as an influential amicus curiae, friend of the court brief. And as probably many of you know, over the years, or certainly in the post-World War II era, the Solicitor General has filed, with regard to all its work, I guess, representing the United States before the Supreme Court, but in addition, as part of that, is filing friend of the court briefs in cases before the Supreme Court. The Solicitor General almost always has enjoyed a very high reputation, both on the court and off the court, for writing highly professional and helpful, high-quality amicus briefs. And among other things, this has enabled the presidency, the president, through the Solicitor General, to explicitly or implicitly advance policy objectives one way or the other. I guess, a great example of this would be Brown, the Brown versus Board of Education, where the Eisenhower administration, through the Solicitor General, filed a amicus brief in support of desegregation. Likewise, it is often said that these Solicitor General briefs can also deliver information, and at least in the minds of some, kind of more objective information to the court. There's some indication that the Supreme Court review, sees favorably the views favorably and helpful most of the time the amicus briefs filed by the Solicitor General, and indeed even in some people who have studied this say that the amicus brief by the Solicitor General can be a signal of support on a controversial issue, if that the Supreme Court might be willing to spend some of its political capital, if that's the right way to put it, if they know ahead of time they have the support of the presidents through the Solicitor General. So how did this play out in Baker? Again, I don't, Professor Carr and all others have talked about this, but just briefly, and others have written about this, and I've referenced this in the paper, but the plaintiffs in Baker versus Carr actually lobbied both the Eisenhower administration and the incoming Kennedy administration to file an amicus brief on their behalf, and indeed they succeeded. As I read the historical record, I think if Richard Nixon had won the presidency, his administration would have filed an amicus brief in favor of the plaintiffs in Baker versus Carr. I'm not sure everyone would agree with that, but part of my evidence for that is a case that I don't think has been mentioned yet in this openly in this symposium, but late in the Eisenhower administration, the Solicitor General's office filed a brief in support of the plaintiffs in Gomillion versus Lightfoot from 1960, kind of a case authored by Justice Frankfurter, no less, that unanimously found for the plaintiffs in that case, and that's a little bit of a precursor in some ways to Baker versus Carr. But at any rate, there was lobbying, and it was proved to be receptive. President Kennedy and his brother, the Attorney General Robert Kennedy, were, for a variety of political and other reasons, receptive to the idea of filing an amicus brief in Baker as they did. And as was mentioned, Archibald Cox, the Solicitor General, eventually files that brief in favor of the plaintiffs and participates in an oral argument. But what's interesting to me is that Cox was actually reluctant to do this. So how could that be? Well, he was a student at Harvard Law School of then Professor Felix Frankfurter. And also, Cox was genuinely uncertain about the role of federal courts in this in this area. He was unsure about how much, if at all, federal courts should intervene in this process. So people have written about this, have these wonderful stories about how Cox and JFK and RFK and others kind of negotiated what should appear in the friend of the court brief. It was eventually filed, and it kind of took a moderate position that it wasn't a political question, but kind of didn't say a whole lot about what the substantive standard of review is. The brief, for example, didn't say anything about one person, one vote, and kind of indicative of Cox's ambiguity about the whole thing is that people have written about this say that after it was actually orally argued twice, and after the second oral argument, Cox, he had participated in it, he had undergone withering questioning in oral argument by Felix Frankfurter, and as he was going out of the Supreme Court chambers, he said Archibald Cox said to one of his colleagues, "Felix Frankfurter is right." This is, Archibald Cox, who just argued the other sides. And there's several reliable sources say that Cox said that on his way out of oral argument. Well, despite that, as of course, Baker goes in favor of the position advanced by the Solicitor General, and all the sources say that the Solicitor General's brief was influential, even though it's not cited anywhere in the opinion. We have the opinion in our materials, and unless I missed it, the Solicitor General's brief is nowhere cited in any of the opinions. Nonetheless, the people who have written about it say that it was influential. Reports of the conference deliberations among the justices in the case have them talking about the Solicitor General's brief. So that and other evidence suggest it was influential. Kind of a similar story with regard to the other reapportionment cases from 1963, 1964 that has already been talked about, Reynolds and other cases. Archibald Cox filed amicus briefs in those cases. in support of the plaintiffs, and those were thought to be influential as well, even though they're not much cited by the, at least in those opinions, by the Supreme Court. I guess I must say on that point, speaking of citation, that not simply because it wasn't cited doesn't mean it wasn't influential, and the reverse is true as well. Just because it's cited doesn't necessarily mean it was usually influential. So bringing that part of the story up to the present time in the paper, I go into some more detail and give more examples of how the Solicitor General, and of course in later administrations, filed amicus briefs in later reapportionment and other important election law cases and Voting Rights Act cases, so I won't go into that. I will briefly say, though, that it's at least a little bit curious to me that Solicitor General, I don't want to overstate the point, has not participated as when the U.S. is a party. Obviously, to any of these cases, the Solicitor General represents the U.S. and there's no amicus brief filed. So it's only when the U.S. is not a party. But I don't want to overstate the point that it's not like in every single subsequent case the U.S. has participated as amicus. But it's a little curious to me that in some kind of high-profile cases the U.S. When it had an opportunity to file an amicus brief, it did not. Just a couple quick examples of that. We talk a lot about partisan gerrymandering, and the Vieth case from 2004, the Supreme Court said 5-4 with no majority opinion that we're not going to intervene in this particular case. In fact, it was a political question, basically, the Scalia plurality opinion said. The U.S. did not file an amicus brief in that case, nor did it, perhaps absurd as it may sound, nor did the Solicitor General file an amicus brief in Bush versus Gore, speaking of Bush versus Gore. And I'm not quite entirely sure what that what that tells us, but they participated. Solicitor General participated influentially in Baker versus Carr, and yet did not participate in Bush versus Gore. So, well, I'm going to move on to Congress, and so time constraints prevent me from going into any detail, but it's been written about well by lots of other people about the negative reaction, and bipartisan at that, too, I might add, in Congress in 62, 63, 64 to these decisions. Senator Everett Dirksen, the well-known Republican minority leader from Illinois, famously spent a lot of political capital unsuccessfully opposing the Baker versus Carr and these other decisions. He and others pushed a constitutional amendment to limit overrule Baker and later cases, and bills that would have restricted federal court jurisdiction over reapportionment cases. They never passed, but some of them passed one house and not the other. They had significant, albeit temporary, support. So that was all, that all faded away by the late 1960s. In the small time I have remaining, I want to talk about something Congress did do, however, that applies to the present day, and that's this institution that us folks in the federal courts arena at least pay attention to, the three-judge district court. And this was something created by Congress in 1910. 1910 to hear challenges to statewide practices, federal court challenges, constitutional challenges to statewide practices, and rather than just have a single federal district judge hear the case with normal appellate review thereafter, there will be three judges convened. It's called a three-judge district court, but actually under the statute it's a single circuit. It's almost always a single circuit judge, and two district judges are convened to hear the case with a direct appeal to the U.S. Supreme Court. So that was in 1910, and actually Baker versus Carr is a three-judge district court case because it was a challenge to the Tennessee statutes involving reapportionment. Reynolds versus Sims and some of these other well-known cases were all three-judge district court cases themselves. So fast forward to 1976, real interesting and puzzling to me change in that statute for other reasons, because it was an administrative burden to the federal court system, at least so some people argued, and because it was thought to be unnecessary. The three-judge district court was abolished, meaning that all the cases would just go through the normal litigation, federal court cases would go through the normal litigation process thereafter, with one exception. The exception being that the three-judge district court was left intact, statutorily left intact, for reapportionment cases. And so, why is that? Well, I've looked over this and written about it previously, and I remain puzzled by it. There is some legislative history about why they left it intact, but it's unclear to me, I guess is what I'm saying. What little legislative, there is some, not much, but it says, among other things, that the drafters of the change in 1976 thought that reapportionment cases were important. That's the word they used. They were important, and that it was necessary to have a three-judge district court as opposed to a single district judge hear the case because of the need for the public acceptance, quote unquote, the public acceptance of reapportionment decisions. So I'm not quite sure what all that means. If in some qualitative way reapportionment cases are more important, quote unquote, I'm not entirely sure. I guess the idea is that, well, three heads are better than one on these sort of things for reapportionment cases, and some notion that a direct appeal would quickly resolve the case or quickly get it up into the U.S. Supreme Court to resolve it one way or the other. Likewise, I guess the idea is, although I'm not quite sure how you would empirically demonstrate this, that three district judges or a three-judge district court hearing a reapportionment case would, however it ruled, would be better accepted somehow by the interested public, or just even by the legal community or something. I guess there's some logic there, but I'm not quite sure how you would measure that, and I'm not quite sure about the direct appeal to the U.S. Supreme Court, how that plays out. So if I can just briefly conclude here, just on the three-judge district court business. So that's how that's since Congress has been relatively passive as under the elections clause with regard to these things, and one of the few things, at least the way I see it, is the Congress has done with regard to reapportionment cases is to have this kind of unique federal court institution, the three-judge district court, remaining to hear these cases. So, one might ask, well, what difference has that made since 1976? And it's hard to, it seems to me, for some of the reasons I just mentioned, it's hard to say. But I want to briefly talk about three things about how one might gauge if it's made any difference, and then I'll end. The first thing is that there's been some talk over the years and some concerns about the chief judge of the circuit, the three judges on a three-judge district court. One of them is the district judge before whom the case is originally filed, and then the circuit, the chief judge of the circuit, gets to appoint two other judges. And so over the years, there's been some anecdotal evidence of what's called stacking, panel stacking, that the chief judge of the circuit, for partisan reasons or political reasons or outcome determinative reasons, would stack the panel with certain federal judges who he or she thinks would rule in a certain way. That's been the charge, and it must be said there's at least some anecdotal evidence that that happens sometime. And an example of that I'll quickly share with you is the Ohio litigation, or potential Ohio litigation that we're talking about with regard to what's going on in Ohio right now. Dan would know this better than I, but so far as I know, there hasn't been a federal court case filed yet. That may be in the near future or something, I don't know, but such a case has not been filed yet. So in the wake of the Ohio Supreme Court decision of just a few weeks ago that said there could be a referendum over the over the map, and I don't know if events today might change that in the Ohio General Assembly, I don't know, but when there was a talk a couple weeks ago about the prospect of a federal court intervention. So this is in the Cincinnati Enquirer a couple weeks ago. It had a story about all this. It says Ohio House Speaker William Batchelder said in a statement that Republicans in the legislature warned the public that the Democrats' plan would stymie the General Assembly's duty to draw maps, so on and so forth, and ultimately have a map imposed on Ohio by unelected federal judges, unelected federal judges, who may be judges from Michigan, Kentucky, and Tennessee. right? I guess that would be the ultimate insult, right? I mean, not only unelected federal judges, but 3 from outside Ohio. What an insult. But I think he's talking about the 3-judge district court, and he is right. I mean, you know, technically he is correct that depending on well, actually, he's wrong, because at least one of them would be from Ohio, right, before whom the case was filed. But technically, the 2 others could be federal judges from outside Ohio. Work I've done and others have done, however, show that in past 3-judge district court decisions of all kinds, including reapportionment cases, it's extremely rare. Almost always the chief judge of the circuit will, I mean, like literally 95+% of the time, the chief judge of the circuit will appoint federal judges from the state where the reapportionment is going on. 2 other things real quick. We've talked a little bit about partisan decision-making by judges. Including federal judges. And so the idea is, do federal judges take partisan or ideological rationales or their background into mind in approving or disapproving of reapportionment maps by state legislatures or drawing the maps themselves. And I think it's the evidence points in different directions, to paraphrase Michael Kang from earlier. It's just, it depends, what data set you're looking at, and it's just hard to say if the 3-judge district court, lessens or heightens partisan decision-making in this regard by federal judges. I think there's evidence pointing both ways. Final thing is, what about the direct appeal? Many of these 3-judge district court decisions in reapportionment cases are, in fact, not all by any means, but many of them are directly appealed to the U.S. Supreme Court, but many of those cases are summarily affirmed. There's not a full decision by the Supreme Court. They'll just summarily affirm in a 1-line decision the case below. That I think on Monday of this week, I think that occurred. A case from Mississippi, I believe, that very thing occurred, a summary affirmance. So again, that and other evidence suggests to me that the direct appeal process, it could cut different ways. So I wish I had a grand slam conclusion here, but on the last point is that I'm ambivalent about the effect of the 3-judge district court as an institution in these reapportionment cases, as opposed to simply, having a case before a single district judge with normal appellate review thereafter. So, the last point is simply that, these are not simply aspects of the original. Both these things I was talking about are not simply aspects of the original Baker case, although they certainly were, and I think played a role in the Baker litigation. But they're, they for good or ill, they affect reapportionment litigation and related electoral litigation to the present day. Thank you.
Good afternoon. Perfect. I'm going to follow up. There's actually an interesting parallel to what we just heard, because I'm going to talk a little bit about the census and the data issues underlying and the reapportionment cases. I'm going to talk almost nothing about the cases themselves and a great deal about what happened afterwards. And a little bit before, but in particular the law called Public Law 94-171, which was passed in December 1975, which lays out the guidelines for the data publication needs that we've used ever since for redistricting. Okay, so in order to start this, I'm also an historian, so you got to listen to the history. You got the founding fathers back there in 1787, as we heard a little bit this morning, sitting in the room together, trying to figure out how to make this government go. And I always like to get their pictures in there so that we see what it was like. It was a very hot room. They had the windows closed all summer, and they came out with the 1787 Constitution that we live with. The government had been going very badly, and the revolution was in some jeopardy at this point, so that the creativity of this instrument is really rather remarkable. And in particular, this paragraph, which is from Article 1, Section 2, Paragraph 3. I'm not going to talk much about the 14th Amendment, but this is the original apportionment clause. which of course had, representatives in direct taxes shall be apportioned among the several states which might be included in this union according to their respective numbers. And this was the debate in the Constitutional Convention, which is how does one allocate both responsibility, namely taxation, and political power, namely representation, in a democratic representative. It wasn't democratic yet, it was a representative assembly. And the decision was to use the whole number of free persons, and of course what you see here is the 3/5 compromise plus the exclusion of Indians not taxed, and the clarification that in what were indentured servants at the time, the people bound to service for a term of years were to be counted with the free persons. And then the setup for the census in the next sentence. Now, why is this important? It turns out the U.S. is the first country in the world to do this, to allocate states in a national assembly according to population. And you add to that the demographic dynamism and diversity of the U.S. population, and the two things together make the census and the statistical system and the apportionment mechanisms central to the functioning of the state. So I'm going to define a little bit about dynamism and diversity, meaning patterns of growth and change, and diversity meaning numerical, geographic, and racial and ethnic diversity. There are many others, but let me start with that. We've gone from 3.9 to 309. It's actually over 310 now. 13 states to 50, 65 to 435 members of the House. The average, this is a wonderful statistic, the average congressional district after this census will be larger than the total population of any of the original 13 states. So this has been an instrument designed several centuries ago that has actually managed, not always happily, but it has managed to the enormous change in the American state over the last 200 odd years. And it's done so while growth has been differential, whereas some places win, some places lose, and that's of course why this process is so painful every decade. I'm going to just sort of visualize this a little bit. This is the 2010 population distribution map that's out. I'll give you a little comparison of England and France, of course, from the constitutional perspective. You can see those growth rates aren't very dramatic. There's the U.S. against it. So that upward swoop was the problem. Through the 19th century, it was almost 30 to 35% a decade of more people every decade. Since then, the population growth has gone down, rate has gone down, but it's still substantial. There's the growth in the states of the Union. There's the size of the House as it has grown for 2 centuries. And of course, this is just a quick example of the differential issue. New York State, just as one very large state that has had a fairly consistent population growth pattern, nevertheless has seen, because of apportionment politics and relative growth in other parts of the country, its congressional delegation grow very rapidly, decline, grow again, decline again. Right? That is, from a popular person's and your garden variety politician's perspective, this makes no sense. How can the one graph go up and the other go down? And that's every decade we have to relearn that, because we all forget what we did, except for those of us in this room, what it was like 10 years ago or 20 years ago. I often ask my students, where were you on April 1st, 2000? Or where were you on April 1st, 1990? As opposed to where were you on September 11th, 2001, right? We don't remember this process very much. This is the 2010 allocation of winners and losers. Most of the losers are in the Northeast and Midwest. The winners are in the South and West. This has been a pattern for a number of censuses of last 40 or 50 years. Geographic diversity. Americans figured out incredibly quickly how to manipulate these the system, if you will. This is the first gerrymander. It's 1812. It's the 3rd census. They figure it out. The paper has other examples, including the fact that the first apportionment in 1792 generated the first congressional presidential veto over the ambiguities left in the apportionment clause about exactly how does one do this. These are just again some maps of the geographic diversity. the expansion over time. The little red dots are the center of population, showing the shift of the population westward. This is a kind of ongoing process. And of course, racial and ethnic diversity, I'm giving you 2000 here, but this is the proportion of the population that's white, the proportion of the population that's African American, and the proportion that's Hispanic Latino. And so you can see that from very large visions, and I could of course scale these back down to local areas as well. The problem, therefore, of drawing districts and dividing up the country has to be managing this dynamism and diversity. Okay. The problem, as we heard this morning, that leads to Baker v. Carr is the decision in 1920 to freeze the size of the House of Representatives, and the inability, therefore, of Congress to use the mechanism they'd used for the previous 120 years, namely increasing the House size each decade to ease the relative loss and absolute loss. Okay. So the corrupt bargain, as I'm calling it, of the 20s was to not reapportion. There's lots of wonderful history about this and what happened. The solution was to do the prospective reapportionment. By the way, the malapportionment was obvious immediately. It wasn't something that you had to wait till the 60s to discover. In the 30s, New York's congressional delegations varied by a factor of 7.8. In other words, the largest district was 7.8 times as large as the smallest. So it was a problem immediately, and they knew it. It was off the political agenda until the 60s, and what now I want to just describe now is the implementation. If you are going to reapportion on one person, one vote, and with accurate numbers, you need accurate data, small tabulations to build as building blocks. They need to be to deal with the question of political jurisdictions. They should be free and open public data, and they need to come out quickly. All right? Turns out that the Census Bureau was completely flummoxed by this problem, and the gold standard that we now have is sort of block level data, only existed for 60% of the country, 2% of the land area. So the Census Bureau gave local legislatures, state legislatures, what was called the Master Enumeration District List, which was, in the jargon of statistics, collection geography, not tabulation geography. And I start the paper with a wonderful quote about how an absurd but fundamental incongruence exists in most states between census geography and political electoral geography. Okay. So in the 70s, Congress takes up this issue with national councils of state legislatures and other interest groups. They passed PL 94-171 in December 75 that amends Title 13 of the U.S. Code to give that the Census Bureau would lay out standards. The states would then lay out their data needs, and that you would create a new system so that the data would then be ready on April 1st, the year after the census. In the 1980 round, 23 states participated. If they did participate, they received block level tabulations and maps. In the rest, if they didn't, and including parts of those 23 states, they still got the enumeration district data. The materials were at that point still paper, computer tape, and microfiche. The variables in the file were total population, 5 race groups, and Hispanic Latino. This is the census blocking of the country in 1980. There's an awful lot of white space there. By 1990, that was all filled in. And we went from having 2 million blocks to 7 million blocks, and the Tiger math system was developed by the Census Bureau. We had GIS come on the scene, and we added one variable to the PL files, what come to be called the PL files, namely the voting age population. All right. So let's ask again, whether we're done. Basically, these are the 5 standards that I'm suggesting that you need. By the 90s, the Bureau had done 4 of them: small area small precincts, easy to use, and timely. And this data has comes out. This is what the census geography for 2000 looks like, and you'll notice what's most interesting about this is that the number of units of the categories, in other words, the reporting categories, so that there are now 8.2 million, a little over 8.2 million blocks that are used as building blocks for reporting the data for redistricting. The average population size is 34. We have what is known as things called, if anybody does this, something called water blocks, which are blocks that are lakes and streams and rivers where sometimes people live in those water blocks, maybe. And I just, to give you an image of it, this is a data dump from FactFinder for the block level data from the PL 94-171 file for Milwaukee, Wisconsin, my hometown at the city. And you'll notice where the red line is that this shows you how many rows there are in this table. It goes obviously very deep down, but it also goes across. And there are, we see here rows 1 to 18 of 7,688 blocks for the city of Milwaukee. So that's the raw data that's put together, that is used. And you'll see that the numbers in the table are quite small. Now, the problem is, therefore, that the block level tabulations are prone to error because of their small size. And it turns out that that also relates and resonates with another problem, which is the census undercount issue, which was discovered at the same time as the reapportionment decisions, and in fact is in some sense is politicized because of the reapportionment decisions, namely that the census counts the total population better than it counts minority populations, and here you have the black versus total undercount data from 1940 to 2000. These are data that the Census Bureau produces every decade, and the differential, of course, impacts on the redistricting process. So the question was, well, if fix this, correct it somehow. So the 70s and 80s, the Bureau spent a lot of time figuring out how to correct it, came up with a new methodology of, I can describe this in detail, post-enumeration, which is a sample survey using dual systems estimation. It turns out, of course, that that most politicians on both sides of the aisle took a look at this and said either ooh goody or no way, Jose, right? Because, in other words, it was an obvious partisan implication of fixing the undercount, as opposed to doing the block level tabulation, geographic tabulations. So the result is that cities and states sued the Commerce Department from the 70s to the 90s. Mostly it was Democratic jurisdictions suing Republican jurisdictions. The final legal resolution was the Department of Commerce versus U.S. House in 1999, where the Supreme Court ruled that the statute, not the constitutional, right, the statute, Title 13, prevented the use of sampling, namely a post-enumeration, for apportioning and therefore adjusting the census, but it might permit it for redistricting or other estimates or other uses. The census was not adjusted in 2000. The Census Bureau could not show that it would improve the accuracy of the tabulations at the block level, namely the redistricting file. They also discovered, and as this research has gone on, that there are still errors in the census, including gross errors. There's the 2000 final estimate, 1.3 million people overcounted. The differentials remain. The block level data is error-filled no matter what, whether it's adjusted or not. And the National Academy panel recommended that the census, that the deadline for redistricting, which is April 1st of the year 1, be moved back a little bit to improve the quality of the census data. That has not happened. The 2010 evaluation program that was only done at the high levels of geography. There's no plan to allocate any kind of error estimates down to the low level of geography, and again we come back and take a look at this, right? And so these evaluations will come out in 2012. We won't know, in other words, whether the underlying data have serious problems until after the redistricting round is done. And it remains to be seen whether that will lead to litigation later in the decade. Okay, this is my plug for the encyclopedia that details all of this. I have a copy and adds, and thank you.
There will be a brief technical interlude. Good afternoon. I am trained as a social scientist and have become, and as an information scientist. But what I'm presenting today will be a policy argument informed by both. From the beginning, this is joint work with Michael McDonald. As Margot said, two heads are more numerous than one, and it's supported by various generous funders. There's a bunch of related work, and warning, this presentation is for educational purposes only, may contain oversimplifications, errors, and/or preliminary conclusions, caveat lector. So look at the published stuff if you want to cite it. This was the thing we were posed. You know, a wide range of legal scholars and social scientists will address the many questions. Among these issues are principles of districting, the nature of representation, voting rights, simple stuff. So all we need to do for redistricting, right, to get it absolutely right, is understand the question of what is the nature of representation. And so there's a simple answer, right? And this simple answer is this, it's a story about a very senior political scientist, and he's world-renowned, and he went, who traveled to Russia shortly after the fall of communism to lecture to the newly formed Duma. And after speaking, a newly minted member of the Duma approached him and asked him a question. I said, I've been elected as a representative. So when I vote, should I vote the way I think the electors want me to, or should I vote the way I think is right? It's a good question. Scholars have been studying this for 2,000 years. Let me just say there are many opinions. In the last 30 years, still many opinions. Right? So what are second best principles for redistricting? Pre-Baker, Baker versus Carr, outcome regulation. So we'll go through pre-Baker, Baker, 20th century, and what might the 21st century bring. Margot quoted the Constitution. We don't need to do that. There are also congressional legislation in each state, provisions on the frequency. That was, and there are some observations. These are some nice New York districts from various early Congresses, displaying various sorts of non-contiguity. Here are patterns of malapportionment, following contiguous boundaries, compactness, following whole counties, and observations, not in the law. You got all that? So, but to summarize and oversimplify, what was happening before Baker, at least through 1913 or so, was there was equal apportionment among states, not so much within states, and often not so much within states by design, because representation was based on a notion of place, whether it was explicitly a set of counties or areas, and people would, sometimes they had to be contiguous and sometimes they didn't. They could say these counties are like each other. We're going to represent these places. Single member districts were not required. There were multi-member at large. redistricting was predominant in theory. Bans on redistricting was predominant in theory for state legislatures, but not necessarily in practice, and certainly not enforced with regularity. Contiguity was actually more common in practice than in theory, and county boundaries they were also more common in practice than in theory, and as a result of that, districts were compact, because counties were compact and districts were made out of counties. It was uncommon that there were less common that there were explicit compactness requirements, and what seems to be driving the compactness was almost always the counties. So what was the problem? Well, to some extent, non-enforcement. By the time Baker versus Carr was decided, there were unprecedented levels of malapportionment, especially at the state legislative level. There had always been racial gerrymandering pretty much at will. There were use of electoral boundary change or lack thereof to maintain large amounts of partisan bias. So Baker versus Carr introduced enforced process restrictions. The idea in this typology is that you remove some discretion from the redistricting authority, and you have some criteria you evaluate ex ante. It's not based on what happens in those districts, what you're predicting. And Baker versus Carr was about equal population, but there are also hundreds of compactness variants. You can apply process restrictions for natural, administrative, media market boundaries, for contiguity in various sorts. But what's the problem with process-based restrictions? So two, actually. One is that they're weak, and the second is that phase neutrality does not have much to do with outcome neutrality. So there's generally a weak empirical link between these various process neutrality and outcomes. Certainly, the population restriction has not prevented gerrymanders, though has reduced the ability to some of the worst malapportionment. And there were unintended consequences. When you look at the patterns of following the traditional districting principles after Baker versus Carr, you see counties being split, less compact districts, lack of contiguity or point contiguity. The other principles that were in play pretty much went out the window. And there can be intended second-order consequences of generally process-based restrictions. Parker illustrates a intended combination of neutral rules. After the equal population decision, Hinds County needed to be redistricted into equal population districts. And so they chose neutral criteria in addition to equal population. Neutral criteria being contiguity, equal area, because the county commissions are sort of responsible for management and of roughly proportional area, and equal road mileage, because county commissioners are responsible for roads. And you put them all together, and you sort of have to take slices of the central urban area, which just happens to have all the minorities in it, and combine them with large urban areas, which happen to have all the roads. So the population plus these other neutral criteria create racial gerrymandering. And there are more general results. We've shown in other work that compactness rules can have predictable partisan effects because of the interaction with electoral geography. The support for both parties is not geographically distributed in the same way. So another line of control were outcome restrictions. We haven't talked about, Gomillion was brought up once, but that was that preceded Baker, and it was not based on process. It was based on the fact that bleaching Tuskegee violated the 14th and 15th Amendment rights of black citizens. So it was the outcome that was the problem, and this line of cases was followed to where it lays rest, and embodied in the Voting Rights Act. But what's the problem with outcome restrictions? Well, there's a lot of indeterminacy. Many different outcome restrictions are imposed, and although we can reach some agreement on some sorts of things we don't like and how to measure them, at least provisionally, like racial gerrymandering in the Voting Rights Act, in order to reach agreement on which outcome criteria to use, we have to go back to that representation problem and solve that. So you can't have it all at once. And so what other principles can come into play? Institution-seeking method, regulation, open institutions. And in the 20th century, there's been a trend around separation of expert and political decisions, sunshine, freedom of information, open hearings, regulatory comment periods, and examples of applying this to redistricting include restricting the types of information that can go into the redistricting process, requiring public hearings, requiring an independent commission structure. So what's the problem with that? Well, the problem is that although this works in some other modern democracies, like the UK and Canada and Australia and New Zealand, which have reasonably nonpartisan redistricting commissions, many US independent nonpartisan commissions aren't. They're either ex ante, or bipartisan because of the way that they're constituted, or they're ex ante non-independent, or they're just weakly resistant to all sorts of ex ante and ex post pressure. And many public hearings on redistricting are theater. You know, they don't change the plans adopted, and they're not designed to produce evidence that can be used by courts later. Though you can get public input about what you like, but if it doesn't materialize into a set of viable alternatives, it doesn't give the court much to do. And still, although much voting records, for example, are public, you have to do a lot of work to get voting data and combine it with census data. And there have been some major project Mike will talk about a little bit, and otherwise, you can go to each of the county registrar's offices and get the data. It's public, but there's still a barrier. So what are possible 21st century principles? Well, transparency, integrating technology to support institutions, to support transparency and participation in institutions. So transparency at internet speed, which means making the data available on the web so that we can actually use it. Open data in open formats about everything that needs that you need to create and reproduce and evaluate the redistricting plan, having an open process, and where redistricting software and other sorts of electoral software is involved, open source, so that the software doesn't become a black box that's manipulatable. Participation, technology gives the opportunity for more direct access to the process. If there's access to tools, then it is possible for citizens to engage in the redistricting process. And this results not only in more participation in terms of engagement, but in terms of the information. You can start to have people identify where their communities of interest are, where they think their neighborhoods are. We have been working in this area, and Mike will tell you about District Builder, but we've had multiple district competitions, hundreds of plans generated, thousands of participants, and millions of viewers. So stay tuned, and I will cede the rest of my time to the gentleman from Mississippi.
Thank you, Micah. So my name's Michael. I'm a recovering gerrymanderer. I've been involved in redistricting in too many states now. I've lost count. Getting just wrapped up in this round of redistricting is overtaking me now. But through that experience, I think I'm one of the few people in this room who's actually drawn districts and presented them to irate members of a legislature who are very upset about, their mother being drawn out of their district or their country club or their favorite donor or having an incumbent of another party in their district or a potential challenger down the road in their district or a community that they didn't like in their district or a community that they wanted in their district but wasn't in their district. So all of those things are the sorts of things that happen during redistricting on the inside. And what Micah and I believe, share are an interest in having redistricting not necessarily represent the interests and needs of the public, of the politicians who are drawing the districts or their consultants, but more of the public. And so that gets us to our project, which is publicmapping.org, and hopefully we got internet. Yes, we do. So the Public Mapping Project is an idea that really originated. I've got to give a lot of credit to Micah for developing, with modest help by myself, an open source redistricting package called BARD for the R programming language. And I know a lot of you lawyers are just crossing your eyes when I start talking about software packages. But and we had worked on this, and I think and we had this idea that we could create automated redistricting. And we discovered, like many other people before us, that automated redistricting is very, very difficult, and in most circumstances won't even produce a viable solution, especially if you have multi-criteria that you have to adhere to. But at an American Mathematical Association meeting, we ran into a mathematician who also is a program director at Sloan Foundation, Danny Goroff, who also shared this vision of getting the public more involved within in redistricting. And we had a conversation with him about how to take this software that we had written that had some very crude, sort of rudimentary mapping capabilities onto it, and really ramp it up to be something that could be used more broadly by the public. And so the Sloan Foundation, the Joyce Foundation, the Judy Ford Wason Center for Public Policy at Christopher Newport University, and Amazon have all contributed monetarily in one way or another to this project, which Micah and I are principal investigators on, and our software development partner has been Azavia, which is a Philadelphia-based GIS firm, and we've been working very closely with state-based groups throughout the country. Earlier, Mark Salling had mentioned the Midwest Democracy Network, so we've been involved with that organization, which is primarily supported by the Joyce Foundation, in deploying the software in Ohio, Michigan, Indiana, Illinois, Wisconsin, and Minnesota to support state and local redistricting. And we've also been engaged in other states with redistricting competitions, and we had one in Ohio, which Mark described. We've had one in Michigan. We're having one right now that wrapped up in Minnesota. Our very first one was in Virginia. We had one in Arizona, one in the city of Philadelphia, and currently underway is a redistricting competition in the state of New York. And so through the software that we've developed, which is a web browser solution, and you can get more information here at the Public Mapping Project, and a link to the New York software. We probably don't have time, so I won't actually demo it, but you can actually go online right now. It's open to the public. You just have to create a username and password, redistrictny.org. There's also a link on this website here, and you can start drawing districts for the state of New York. And you're doing it through your web browser. The program's completely open source, and which again, it goes back to the principles of transparency that we believe very strongly in. If we're going to apply that to institutions that are drawing district lines, we believe that it should apply to ourselves as well. So open source, the data we also document, and it's publicly available on the public mapping website as well. Disaggregated election data down at the block level, which is what you need in order to evaluate the different effects of different redistricting plans. Now, we've learned a lot in this effort. We've been engaging the public and primarily students, but also others in these redistricting competitions. And we've educated students about the issues of redistricting and the trade-offs that are involved between different criteria, educating people about what the Voting Rights Act is and what those requirements are, and what are the consequences for opportunities of drawing districts elsewhere within a state or a locality. And as a consequence of educating these, particularly students, again, in these competitions, we discovered quite by chance, or maybe by design, lucky design, that the media really latched onto this story too. Because we had taken a dry process story about redistricting and made a human interest element, which was a contest with prizes. And we've had really wonderful media coverage about these contests in Virginia. Over 30 local media stories and in newspapers, radio coverage, television coverage. Our best story to date nationally would be, and USA Today did a feature on what we were doing in Virginia. So as a byproduct of educating these students through these competitions, we've also educated the public about the importance of redistricting and some of the trade-offs that are involved, because the media have been able to take a story that is difficult for them to cover and put a new face on it and cover it in a different way. So we've had a lot of success about educating the public. And we've also had success at educating policymakers about redistricting opportunities. Some people, when we first started this project, didn't think that the public could draw a legal redistricting plan. We've proven that to be wrong. Students have drawn legal redistricting plans. In fact, the second place congressional finisher in Michigan was a 10-year-old. And many of the editorial pages thought that he did a better job than what the state legislature did in terms of redistricting. So if it's as simple as a 10-year-old can do it, it tells you that it is very difficult. I mean, don't get me wrong, redistricting is very complex, and if you get in and start working with the software and drilling down to the census block level, as Margot probably knows very well about, and you get into road medians, which are census blocks, and oh boy, and you draw districts and you'll lose those things as you're drawing the districts. It's very tedious, to say the least, when you're drawing districts. But it's possible that people can do this, and we've had students in Virginia in particular draw districts that informed the governor's independent bipartisan advisory redistricting commission. Now, they were doing that because I was working as a consultant for the governor's office on the commission, and so I was taking the plans that the students were developing, and I was presenting some of those plans that I thought were interesting ideas to that commission. And some of the plans that we eventually adopted were plans that the commission, that the students actually were ideas that the students came up with. So we had a very direct link there, and of course I was the bridge for it. So maybe you discount it. And of course, the governor issued a veto of the first state legislative plans in Virginia, and he did cite the commission's work in that veto, but the subsequent plans that he did assign weren't all that different than the first round, which the legislature did, which did ignore somewhat what the students were doing, but not all of what the students were doing. For example, a team from the University of Virginia drew a redistricting plan that had 6 state Senate districts that were majority African American. And currently there's only 5. And I talked with the Department of Justice, I talked with the state consultants who were drawing those plans, and they were very interested in that 6th Senate district because they thought there was a viable voting rights issue because they could draw that 6th black voting age population majority district. As it turned out, people did some additional analyses of that district and determined that it would not be an effective district because it was just a bare majority district, and so the state Senate did not draw that district. But they did look at it very seriously. And more importantly was a district that the William and Mary Law School team developed, which showed how to draw African American influenced congressional district in the southeastern part of Virginia. And that particular district now, or at least the concept that's embodied in it, has become the sticking point in negotiations between the Republican-controlled House of Delegates and the Democratic-controlled Senate. And we don't have a congressional redistricting plan in the state of Virginia. It may be that the plan that will eventually be drawn by a special master, and in that case, maybe that special master will look favorably upon some of these ideas like the one the William and Mary Law School team came up with. So we've had these real successes. In Minnesota, they also have a divided state government, and in that state, a state Supreme Court has taken up the ball to draw a redistricting plan, and knowing that we have the software working in Minnesota, the state Supreme Court has worked with Common Cause to make sure that plans that we draw with the redistricting software we've deployed there will be considered by the state Supreme Court. So there we have a very direct input into the process. We had a very direct input into Arizona as well, but that commission was working more on its own than taking some of the input from what we were doing. And then lastly, we're in New York at the moment, and so it's possible that competition is underway at the moment, and it's possible that the governor, who's said that he would veto plans in the state of New York, may look favorably upon some of the student-drawn plans in that competition, or we may again end up in a special master situation if there's no agreement between the governor and the legislature on maps. And so again, we could see a special master in that circumstance look favorably upon what the public is doing. So we theoretically, as academics, we had this idea that public participation in redistricting could be good, or at least produce different outcomes. And we've actually achieved that in some ways, and we've achieved other goals about educating the public about redistricting. And for our own academic interest, we're collecting these plans, as Micah mentioned. We're collecting plans, by the way. I wish we could take credit for some of the other things that are going on out there, but in Dallas, there was a local redistricting that a librarian drew the plan for the city of Dallas. There's other software available out there, and ours isn't the only one that enable people to draw redistricting plans. So we're collecting those as well. So everywhere there's public mapping that's going on, we're collecting up the plans. And one of the things that we're doing is, as Micah has laid out, they're all, and what we've been discussing today quite a bit, frankly, in the wake of Baker, is that equal population, in some ways, voided out some of the state constitutional requirements on respecting political boundaries, compactness, et cetera, because those had to be subordinate to the equal population standard. And as we're getting plans developed and drawn, we're able to start mapping out the trade-offs between different criteria. We could see what the difference of relaxing or restricting that population deviation is on other criteria as we see plans that are being developed, which is something that we haven't been able to do before, really, as academics. And I would suggest that most of the academic literature and scholarship on redistricting is fatally flawed, because we are selecting on a dependent variable. We are selecting on the plans that have been developed through the political process that embody the political goals, and we don't really set up the proper counterfactual, which is what would happen if other things were happening, if we were following a different set of criteria. And so by getting these maps together, we're able to start fleshing out what those alternative hypotheses or those counterfactuals may actually look like, and give us a better sense about what is the effect of a compactness requirement on political fairness or some other value that we may care about, and see in a better way, in a more academic way, what the reform efforts to, like in Arizona and California, other places, what could be achieved in various political settings across the country. So we've had pretty good success, and we're hoping, of course, we wanted to educate the public about this whole process and educate public policymakers, which we've achieved those goals. And we'll see now if we might be able to educate academia as well, coming back with some of the data that we're generating from our project. So thank you very much.